Okay, let's just dive right into this explainer, shall we? Today, we're unpacking a landmark 2025 Supreme Court case that, honestly, fundamentally redefined the boundaries of Indian federalism. I'm talking about the State of Tamil Nadu versus the Governor of Tamil Nadu. Now, you might be thinking, oh, another dry constitutional theory, but trust me, this is anything but. This is a high-stakes, real-world clash over who actually holds the ultimate power to make laws for the people. So just imagine for a second sending a crucial, super urgent message to your boss, and they just leave you on read. Not for an hour, not for a day, but for 3 entire years. I mean, no way, right? Well, what happens when a state's democratically elected legislature passes a law and the appointed governor simply doesn't respond? This exact scenario is the compelling question that triggered a massive constitutional crisis in India. And the stakes in this standoff? They absolutely couldn't be higher. On one side, we have the DMK-led Tamil Nadu government, and on the other, Governor R.N. Ravi. The state government essentially accused the governor of deliberately obstructing their legislative agenda by just sitting on bills. It got so intense that the Supreme Court of India literally had to step in.
Here's our roadmap for this explainer. We'll be covering 1. The state versus the governor. 2. Understanding Article 200. 3. The pocket veto problem. 4. The Supreme Court verdict. 5. The presidential reference. And finally, 6. The impact on Indian federalism. Let's get into it.
Section 1. The state versus the governor. The 3-year standoff.
Okay, so picture this timeline. Between January 2020 and April 2023, the Tamil Nadu Legislative Assembly passed 12 different bills. A lot of these were designed to shift the power of appointing university vice-chancellors away from the governor and over to the state government. But the governor just sat on them for years. Finally, fed up with the whole shebang, the state filed a Supreme Court petition in October 2023. And suddenly, almost out of nowhere, the governor officially withheld his assent. So what did the assembly do? They immediately convened, repassed the bills, and sent them right back to his desk.
This entire situation led to a pretty striking remark from the Chief Justice of India during the hearings. He openly asked, what was the governor doing for the last 3 years? I mean, it really highlights the court's sheer disbelief. You have the highest court in the land having to pause and ask why the basic machinery of state governance had just completely stalled.
Moving on to Section 2. Understanding Article 200, the Rule Book.
To really grasp why the Supreme Court intervened here, we need to look at the actual rulebook. When a bill lands on a governor's desk, they have exactly 3 mutually exclusive options. Option 1, grant assent, and boom, it becomes law. Option 2, withhold assent, but, and this is a big but, they must return the bill to the legislature for reconsideration as soon as possible. Or, option 3, reserve the bill for the President of India to review. That's it. Those are the only choices on the menu. But wait. What happens if a bill is passed a second time? Well, on that first pass, the governor has those 3 choices we just talked about. But if the legislature comes back and says, no, actually, we stand by our law, and they repass the bill, the rulebook changes entirely. All those options disappear, and granting assent becomes absolutely mandatory. No way out. Which brings us to Section 3. The pocket veto problem, the constitutional loophole.
So if the rules are so clear, how on earth did a 3-year delay happen? The answer lies in a massive loophole known as the pocket veto. Basically, this is when a governor just puts a bill in their metaphorical pocket and does nothing. Because Article 200 originally lacked a strict time limit, it only said as soon as possible, well, some governors treated that vague phrasing as an invitation to delay indefinitely. And it wasn't just Tamil Nadu. This idea was spreading like wildfire to states like Kerala, Punjab, and Telangana too.
As you'd expect, the Supreme Court took a very stern view of this practice. They ruled impartially that the governor's failure to act simply lacked bona fide or good faith. It was deemed unconstitutional and obstructive. They clarified that withholding assent means temporarily deferring a bill for reconsideration. It absolutely does not mean permanently blocking it through silence. Now we're at Section 4, the Supreme Court verdict fixing the timelines.
This is where we hit the climax of the explainer. The landmark April 2025 judgment by Justices J.B. Pardiwala and R. Mahadevan. Justice Pardiwala actually opened with a really powerful remark. He noted that the constitutional framers envisioned the governor as a sagacious counselor, someone who's supposed to calm tensions and, as he put it, pour oil over troubled waters. But instead, the court found itself dealing with the exact opposite, a bitter legal battle that just churned up the waters of a high constitutional order. So, to fix this giant loophole, the court effectively laid down a constitutional stopwatch. Step 1. When a bill first arrives, the governor must make a decision within a maximum of 1 month. Step 2. If they choose to withhold assent against the advice of the state cabinet, they have to return it with an explanatory message within 3 months. And Step 3. If the legislature repasses the bill, the governor must grant mandatory assent within 1 month. Clear, strict deadlines.
Let's just quickly summarize the core legal takeaways here because they are absolutely crucial. First, the options under Article 200 are mutually exclusive. Second, there is no absolute or pocket veto in India. Period. Third, a governor cannot suddenly reserve a repassed bill for the president if they didn't choose that option the first time around. Fourth, the governor's personal discretion is strictly limited to very specific constitutional scenarios. And finally, and this is a real game changer, gubernatorial inaction is now firmly subject to judicial review.
All right, Section 5, the presidential reference, clarifying the rules.
Now, shortly after the ruling, the president actually referred the matter back to the court for a bit more clarity, and this nuance is super important. The court clarified that, sure, they reject the idea of automatic deemed assent, meaning a bill doesn't just magically become law the second the clock runs out. However, the timelines they set up are strict tools for judicial review. They aren't constitutional amendments, but they give the courts a concrete yardstick to measure against. If a governor blows past these new deadlines without a highly compelling justification, well, the courts can and for sure will intervene.
Finally, Section 6, Impact on Indian Federalism, the Big Picture.
So what's the big takeaway from this State of Tamil Nadu versus Governor of Tamil Nadu case? Why does it matter to everyone else? Well, demystifying Article 200 really protects the federal balance. It reinforces the legislative supremacy of democratically elected state governments and puts a hard legal stop to prolonged political obstruction. By establishing this procedural fairness, it sets a direct precedent to help resolve similar ongoing constitutional deadlocks in states like Kerala, Punjab, and West Bengal.
We'll end on this final, pretty provocative thought. By turning these once vague constitutional conventions into totally enforceable legal guardrails, the Supreme Court has fundamentally altered the playing field. So how will these new guardrails reshape the balance of power between elected governments and appointed governors moving forward? It's a fascinating new chapter in Indian constitutional law, like a giant puzzle coming together, and it's one we are definitely going to be watching closely. Thanks so much for joining me for this explainer today. Keep asking questions and keep learning.